In recent years, romantic unions have evolved beyond the traditional marriage. And while a marriage or common law relationship is a loving partnership between two people, it can also carry, and does carry, legal and estate considerations, especially in the 2SLGBTQ plus community. Joining us now is Nicole Ewing, Principal of Wealth Planning Office at TD Wealth, to discuss some of the considerations. Nicole, I have a list here, and again, you're putting out a great note on this, and I'll say that's available to clients. Quite interesting. But I want to start with common law, and the legal definition of common law does vary across the country. Maybe give us some of the general parameters.
Yeah, it's very important that we recognize that these rules are provincially specific. So depending on what province you live in, the definition of what counts as a common law partner for the purpose of, for family law and estate law purposes can be quite different. Generally speaking, it would be either 2 years or 3 years cohabitating together in a conjugal relationship. It can speed up if you have children together, or one of you becomes a parent of the other one's child or assumes those responsibilities. So the definition can vary quite a bit. And then interestingly, for tax purposes, it's actually 1 year of cohabitation with your common law partner. So you could be common law for tax purposes and subject to all of those rules as a union, and yet not common law for purposes of family law or estate planning purposes.
Yeah, that was actually, again, whenever I read your note, I had these little aha moments when I go through them. And my one was when you said that common law couples are treated equally to legally married couples for income tax purposes. But that is not the same when it comes to everything else, when I think with the estate and that type of planning too. So, you know, what should couples be thinking about then from an estate planning standpoint and family law standpoint, maybe that they haven't been, and maybe assume they have certain rights they do not have?
Absolutely, and people conflate them all the time, and it's important to understand that if you have done nothing and you have no documents currently in place, there are still rules that are going to apply to you. I call them the default rules. That's the legislation that says what will happen if you are a married couple and if you are a common law couple. That's the intestacy rules that will apply to you for your estate purposes. You have the option, however, as a couple, as an individual, to choose how you want your assets to be distributed, to choose who you want your executor to be, to name the people that you want to be involved in your children's lives, and to explicitly state that in your wills, in your powers of attorney, your representation agreements, your trusts, if those are relevant, and to really plan to ensure that you are being intentional about who is going to be involved in your estate and what they're going to receive. It's also really important to think about outside of your own relationship and think about who else might be drafting their own documents that could be potentially naming you or naming your children or your spouse, and whether or not they have the advice that they need in order to ensure that their wishes are going to be respected. And so we think about things like grandparents or other family members who want to leave assets to you, your spouse, or your children. It's important that they understand that maybe some of the assumptions they're making about what might happen and who qualifies as a child for legal purposes or as a spouse for legal purposes needs to be closely examined. And even if you have documents in place, those might need to be updated to reflect your family and the reality of your family and how it came together. All the details are really important.
Can we maybe dig into that one a little bit, because it's interesting, because you mentioned often maybe the couple will think about themselves, their children, and that immediate unit to make sure things are taken care of. But you highlight a great point about extended family, and especially I know you're speaking to my producer, talking about how the language that maybe in some of the documentation excludes children not born in marriage, or an unmarried couple with children, or in a parental partnership, things they have to consider. So do you have an example you can share with us?
Oh, many, and this has I'd say that the language has changed quite a bit over the years. The definition, right, when we're speaking about parentage, really has shifted and changed away from referring to biological and adopted children into a more comprehensive view of what that includes. But there are many documents out there, and I see them all the time, that still include what we would have been considered boilerplate clauses that just were thrown into every will to define who would be a spouse or who would be a child. And very often, if you're looking at wills that were prepared, before, maybe in the early 2000s or before, they contain language that say the definition of a child only includes those born within marriage. And so by definition, that's not going to include your common law children. So think about for a moment your parents, right? If they have that language in their will and you have a common law spouse with children, they may have accidentally disinherited their grandchildren simply because of this default language or this boilerplate language that was in their will. And in speaking with a colleague of mine, she was saying that this happened in her own family with her wife, and they were speaking with their parents and reviewing their wills and saw the references, and she had to point out to her parents, like, did you realize that you have disinherited one of your grandchildren by virtue of the fact that they had both been they had conceived their children through surrogacy, and so when we think about surrogacy and IVF and even the genetic material that might be part of your estate that you need to be planning around what you want to happen to that genetic material. All of those sorts of issues are really relevant and need to be accounted for, not just for yourself, but also for your extended family as they're thinking about even the definition of a child. And so if there is for example, genetic material, if a child is born at a later date, will they be included or excluded? And that will depend on the language that has been built into the estate planning documents for yourself and that your loved ones have also prepared.
It's fascinating. Can I ask you, I've got a couple of quick ones that I wouldn't mind throwing in here too as well, Nicole. Powers of attorney, you also said there's some important considerations around that.
Be really, again, intentional about who it is that you want to provide for you. So again, you have the opportunity to name the individual who will step into your shoes. Now, neither married nor common law people automatically have the right to make decisions on behalf of their spouse. If you don't have those documents in place, your spouse will need to actively get court authorization in order to act on your behalf. But we want to be careful as well about things so if, for example, you are receiving certain types of medical treatment, you want to be ensuring that the individual that you name as your attorney for personal care, for example, is going to honor and respect the choices that you've made for yourself and that will continue the care that you need to be living your life the way that you choose to. That's why it's very important to have these documents and to name people that you trust and that you know will respect your wishes as well.
And also, I'm assuming very important to have the use of correct names, correct pronouns as well.
Well, and there can be some, I'll say, wiggle room here. So really the intention when you're putting the language, when you're naming people within your documents, the intention is to make sure that you can identify who they are. And so as long as the law can identify who the individual is that you are referring to in your documents, generally speaking, they will be able to inherit, for example, if you've named them as a beneficiary. But to the extent you can, you want to be really clear and ensure that the names that you are using on different documents matches your legal name. And if it doesn't, that you are having your legal advisor make specific reference to that. So they may say also known as, or will define the terminology when it comes to gender as well, ensuring many lawyers are drafting to say they, them, theirs, and that refers to all genders, whereas language used to refer specifically to him or her. And so making sure that the documents that you have should reflect who you are and what you wish for yourself and your family. And when you're working with legal professionals and other professionals together, they can help guide you and ensure that those documents reflect what's important to you, but also make sure that you can navigate some of these more technical legal issues really carefully. So the language that you're using, the pronouns that are being used, the specific names that are being used, and making sure that those reflect you and your family. And again, if you have extended family members who are preparing their documents, you might want to raise some of these issues with them as well, just to make sure that there's not any sort of inadvertent oversight.
The last question, I always do this to you. It's a long question. I'm not going to give you long, but give us just some important considerations. When a relationship breaks down from an estate law perspective, how do you think about it?
Well, this is where we look at, again, defined terms and the legislation and the default rules that will apply. And in each province, there are different rules that determine when a relationship ends, whether or not you are separated. If you are legally married, what the difference between being separated and divorced can have different implications about whether that person will still be able to inherit, whether they will be able to be your executor. And so being careful to understand where the beginning and end of a relationship is, and perhaps documenting that, because intention really does go a long way here, and making sure as well that, again, your family members are aware. Sometimes these are sensitive topics that we don't necessarily want to be sharing with others, but it can be very important that they understand when you've entered into a relationship and when you've exited that relationship, so that they can reflect on their own documents and determine whether or not some adjustments need to be made to represent the reality of your situation, and make sure that we're not inadvertently including somebody we don't want to include, but also not excluding a loved one, and particularly where there's chosen family. It's important as well.